Everybody, welcome to the Insurance Journal's Academy of Insurance's weekly webinar Aftershow. I'm your host, George, and joining me for the Aftershow today are the director of the Academy of Insurance, Mr. Patrick Raitt, the questionably hydrated director, as he keeps drinking water, and our instructor for today. Our instructor taught us about EPLI basics, and his name continues to be Casey Roberts. Casey, welcome to the After Show. It's great to have you here.
I refuse to use the alias until the federal government says I'm out of the witness protection program.
So that's fair enough. Good.
So Casey, you taught about the basics today. So some people who might be under the impression that EPLI stands for a certain kind of record only sold in the cities of in record shops in Hempstead, New York, Islip or Oyster Bay, or extended play Long Island. That you shattered that misconception today, and I want to thank you for making sure we don't know that EPLI basics stands for extended play Long Island, but Employment Practices Liability Insurance. Casey, thank you for getting us on the straight and narrow with that. Really appreciate.
I'm going to have to go to Oyster Bay one of these days to figure that out, but thank you. I will.
Well, thank you. And it was an action-packed hour of workplace liability. And I wanted to know, I think work comp insurance itself has been around a lot longer than EPLI, if I'm not mistaken. EPLI, was there a lack of coverage of the things that EPLI indemnifies a company against before EPLI was, or is EPLI a more formalized way of protecting companies against employee liability?
You just brought up some ancient history too, George. I don't know if you know this. So workers' comp, first state to pass a workers' comp law was 1911 was Wisconsin, and New York was right behind them. A little bit of trivia for you that just sticks in my brain. But in the, I want to say mid to late 70s, there were some legal judgments that said that workers' compensation should apply to wrongful employment discrimination and things of that nature, and wrongful discharge, if I'm remembering correctly. And the workers' comp underwriters everywhere said, no, that's not the intended use for it. And so there's now a specific exclusion in workers' comp. And so then out of that came a distinct and definite need for employment practices. Not just that, but we needed some sort of way to, once these laws started to be passed, to protect insureds, those who chose from a risk management perspective to transfer their risk to an insurance company. We need to have a policy, a program, a way to protect them. And so the initial development of EPLI came about. And initially it was just pretty much, if I recall correctly, and Patrick can probably chime in on this as well, it was initially just about workplace discrimination. That was pretty much it, right? Title VII of the Civil Rights Act, 1994 passed, unlawful to discriminate, sex, national origin, that kind of stuff, race, color, creed, if you will. And so when folks were doing that, it's definitely excluded under the general liability because it doesn't amount to bodily injury or property damage. It doesn't qualify under the definitions that we see in the CGL under personal injury or advertising injury. And so when you've got a void, right, and George, you've got so darn many insurance classes, I can't believe you're not teaching some of these, right? But you know that when a policy excludes something, there's reasons for it. It's a catastrophic loss that we can't finance well, or it's against the law, like contraband, et cetera, or it's better covered under another policy, right? And obviously the better coverage here for anyone to ever consider is an EPLI policy. So a very long answer to a shorter question.
No, not at all. And you really dive into the nuts and bolts and the amoeba of the policy. I had a question about something you mentioned on Today's Realities. You had a slide called Today's Realities, and you talked about different things that the EPLI insures against. One of them was sexual harassment claims. And you said that that a claim that sexual harassment was claim worthy even if the harasser is a non-employee. So how can you sue a company for sexual harassment if the entity doing the harassing is not an employee of that company?
So that's where you start looking at third-party losses, third-party claims. So depending upon how the policy is written, and that was one of the last things we addressed in the closing remarks, was third-party liability losses, right? So if a non-employee brings, let's say an employee of the Insurance Journal sexually harasses the UPS driver, if you will, right? And the UPS driver takes legal action against the Insurance Journal. That's going to be a covered loss under the policy, right? And it's going to be covered depending upon the basic policy language, or it's going to be covered upon a third-party exposure.
Okay, got it. Okay, well that makes it a lot clearer. Thank you, Patrick.
I try.
Patrick, welcome to the Aftershow again. And what do you think of EPLI basics in general and Casey's class in particular?
Sure. Yeah. And this was a great topic for Casey to dive into this year because we don't have a whole lot in this particular realm. No reason other than people largely focus on property or casualty or auto, things like that. And so adding this to our catalog made perfect sense when Casey suggested it, because this is an important topic for many reasons, not the least of which being that harassment or wrongful termination or improper hiring practices are all things that happen. And it can be anything from as small as somebody says that they were fired for a bogus reason, and to larger things. We were talking about those third-party claims. This also protects if you've got an employee who is harassed by a customer, and the employer doesn't take proper steps to protect their employees against that kind of thing. And there's this is such a broadly needed coverage that I think it's great. And Casey, you didn't necessarily bring it up, but I'll just kind of throw this at you just as a thought. We know that certain policies like the BOP has an EPLI kind of endorsement that's available. Would you say that a customer who's getting their coverage on a BOP, do you think that's sufficient, or is that maybe just a stopgap kind of measure till they get a more robust EPL kind of policy in place?
Whereas you were almost going to say until they get a real EPLI policy in place.
I saw that close. That close.
Yeah, but I was going to fill that. I'm sitting there going, yeah, exactly. No, and you're giving me the softball question. I appreciate it because I know we've had these discussions before. I mean, it's similar to the cyber discussion, right? A number of BOP carriers will provide an insured with, say, $25,000 of some sort of cyber coverage. Well, and that's what it is. It's some sort of cyber coverage. It's some sort of EPLI coverage. But it is, as you know, this one advertisement I keep hearing on the radio or on various feeds goes, it's a Band-Aid for a shark bite, right? It's just not enough. It's almost akin to having the minimum liability on your auto policy, right? Sure. Well, the state says I only have to carry $25,000. Fine, but when you hurt someone and the lawsuit is for a six-figure judgment, your $25,000 is again a Band-Aid. So now I think the real way to attack it is a standalone. Worst case scenario, I'll go ahead, as I mentioned in the class, I'll go ahead and write it as part of a larger executive management program, and then maybe it's going to share a limit with the D&O. I'd rather have that than have a BOP endorsement. But my number one preference is a standalone monoline, mano a mano, if you will, EPLI policy. Yeah.
Yeah, and you brought up a great point. You're talking about the hammer clause. and insureds may not realize, and I think insurance companies don't always recognize. Maybe they do, but they're thinking differently. But from the insured standpoint, they're thinking about, if I settle this thing, what does that say about me and my company? The company's saying, if we don't settle this thing, we're going to pay a lot more money on the other end. And those hammer clauses, they're there really to protect the company. In my mind,
I think they really are. And as I mentioned, it's all about protecting the insured's reputation. Now, is the insured's reputation going to be better served by settling out of court? Oftentimes, in sometimes what is either agreed to be, for better or worse, a confidential agreement, or would the insured rather have their name dragged through the mud through litigation? And so I think part of it is kind of like a slap upside the head to the insured saying, look, you got an option here. It's not a swell option, right? And the ISO example I used from their policy was just like, boom, 100% hammer. You're responsible for everything moving forward, right? That's severe. Not all policies are like that, but a lot are. And the reason is because we've got a dollar figure. We can settle this now. Let's get it done, right? And we're actually, as you said, we're actually protecting the insurer's reputation, I think, to a greater degree. So, but if we didn't have that language there, the insurer could say, no, I'm not going to settle. We're going to keep going. And so the carrier then would be, as we say, it is the carrier's money. Yes, the insured paid a premium, but it is the carrier's money at risk. And so there has to be some respect for that.
Yeah, for sure. And I think I agree with you that the faster it's out of the news cycle, the faster it's out of people's memory. A lot of these things, they go away. People forget. Not everybody, obviously, but there could be some reputational damage. But the one thing I think about when it comes to reputational damage is that once the damage is done, then you can start the rebuilding process. And if there's yes, there was an issue over here, they, given the right whatever, they can get past it.
Oh, I don't disagree at all. I mean, it's a great tool. I mean, one thing I didn't even get a chance to talk about with some of the basics was that normally when one buys an EPLI policy, they then gain access to HR professionals regarding should they have a potential claim or an issue that they need help with. And normally that's included in their premium charge. So they then don't have to go out and access, I know one of the leading firms, I think, in the nation is still a attorney firm called Littler Mendelson. And they have been around for years doing virtually nothing but employment practice law and HR practices. And I remember selling policies and we had access to Littler Mendelson. It was the greatest thing ever. You thought you had a problem. Hey, I'm going to discharge this guy. What do I want? And they would walk you through the process. This is what you need to do. This is what you should be aware of. This is how you avoid that. And so what a great risk tool. Mm-hmm. And you're getting that for a few $1,000 in premium. It's great.
Yeah. And that's the kind of thing that comes with several different sorts of policies, and the things that people don't think about when their agent says, here's this policy and here's what it's going to cost you. The other things that come along with that, cyber policies where half of the underwriting process is setting you up for good cybersecurity, things like that. EPLI policies that come along with maybe sample policies and procedures and access to people to discuss these things with. So yeah, there's a whole lot more to it than just an insurance policy.
Yeah, I'm just sitting here and I'm thinking, geez, we're selling it the wrong way. Instead of selling it for the loss, let's sell it as a loss prevention tool.
For sure.
And some folks will think, well, that's what their agent should do anyway, is be the loss prevention guy or gal. But when you start talking about coverages that are so specific and laws that are so specific regarding discrimination and things of that nature, you really need to bring in, this is not time for amateur hour. You really need to bring in the pros.
For sure.
Yep.
Casey, is there anything you didn't go over in today's class that you're going to go over in your appearance with us on September 18th, Emerging EPLI Risks?
Of course. I'm going to talk about the emerging stuff.
Such as?
We don't know. I've got a whole month to figure that out.
Oh, they haven't emerged yet. Oh, yeah.
But I will tell you one consideration that I'm going to work into the presentation is the use of artificial intelligence, AI tools in employment. And I think we're going to see, I have to polish up my crystal ball and do some more research, which is why it took a whole nother month to do it. But I think we're going to see some law develop in that regard, and that could be problematic. I attended a conference a few months ago, and one of the questions it was primarily is about 2 full days of AI. And you would think that was overkill, but I think we just scratched the surface. But one of the questions asked was, okay, if I as an individual utilize AI in some of my business practices, has that AI tool now become an agent of my organization? And I'm sitting there going, gee, I don't know. But I mean, I'll guarantee you when we start reading some of those disclaimers on the AI access points, they're going to say, hey, we're not responsible for nothing, no how, no way. Thanks for calling. Mm-hmm. Right. But again, those are considerations. I think this is a developing area. So I've got to drill down and look at that and see what the folks at the American Bar Association have to say about that and things of that nature. So that's what I'm leaning towards at this point in time, where we'll see what some of the coming losses are, et cetera, and maybe we can cut them off at the pass, as they say.
Yeah. Much like the Beatles used to emerge they would go into the studio and emerge with a new album. You're going to go into your insurance genius yurt and meditate and ruminate, and you're going to emerge from there with a new class about emerging risks. It's a little double entendre action there, Casey. What do you think?
Wow.
Gearing up, gassing up the yurt for some sculling out sessions on the emerging risks. We got you.
George, I'm going to have to invoke my inner George when I start putting this class together, and I'll reach out to you from my yurt.
Well, my outer George will welcome any communication, astral, telekinetic, whatever. Otherwise, Casey, I had one quick question, and you mentioned that my tones were mellifluous, and I appreciate it. Mellifluous is not a word that normally is uttered in the academy classes, but you talked about researching racial discrimination, and you talked about a mechanism called the old Googler. And I was wondering the old Googler sounds like a character on a children's show, like a farmer telling children's stories. And now here's the old Googler with Gretel and the Beanstalk. What is the old Googler, Casey?
That's the Google search bar, brother. That's all it is.
The Google search bar is the old Googler. Got it. Racial discrimination.
That's what we're going to be calling the people who use their manual search bar in their computer rather than asking AI questions.
The old Googler.
I'm an old Googler.
Yeah. Man, what's the old Googler say? I don't know. Let's go check him out and ask him. Yep. It'll be by cracky. It'll be fascinating.
The old Googler.
The old Googler.
You heard it here first, Aftershow viewers. The old Googler. We now know what that is. So if Casey mentions the old Googler again, I won't ask again because now we'll know. My inner and outer George both know about the old Googler. So, Casey, thank you for clearing that up as well.
The things one can learn on the Aftershow.
Another veil lifted.
That you can't get from the regular classes.
Thank goodness.
Patrick, I've been worried about your hydration, so I'm glad you Googled some water.
Hey, it's Florida, and it's cool today at 87. So,
I'm in Arizona, and we are reaching for a chill 106 where I am.
Wow.
But remember, Patrick, remember, it's a dry heat.
That just means that you're being roasted.
Patrick, thank you for braving the thunderstorms that are impending on you to appear at the after show. Really appreciate it. Casey, thank you for another hour of amazing knowledge, intense warmth, and convivial general humor. Really, always a pleasure to have you working with us, and want to appreciate that.
Well, you guys are awesome, and thank you for that. I appreciate those comments, George, sincerely.
Yeah, absolutely. On behalf of Patrick and Casey, this is George, your host, saying thanks everyone for coming. Use the old Googler as much as possible, and we will see you next time. Have a great day, everybody. Take good care. Old Googler.